SJC-11927, Federal National Mortgage Association v. Edward M. Rego and another.
Mr. Weinhold, good morning.
Chief Justice and Associate Justices, may it please the Court, Michael Weinhold on behalf of the homeowners and appellants Edward and Emanuela Rego. In this case, the Housing Court made 3 mistakes. The first mistake was that the foreclosure sale was void because the bank failed to authorize its attorney in writing as required by Chapter 244, Section 14, statute that rests at the heart of the statutes related to the power of sale. The second, the bank in this case failed to prove its case to establish its prima facie case by providing either a valid affidavit of sale or competent extrinsic evidence. And third, as this court is held in Bank of America v. Rosa, the Housing Court has jurisdiction to hear Chapter 93A counterclaims in a post-foreclosure summary process case. Turning to my first point, Massachusetts is a non-judicial foreclosure state, and that means the legislature has made a trade-off. Banks do not have to go to court before they foreclose. There will be no judicial oversight unless the foreclosure is challenged in an eviction proceeding. And the trade-off is then that banks have to strictly comply with the power of sale. This court has held that any violation of the power of sale, which includes the statutes related to the power of sale, will void a foreclosure sale. This court has held that for over 100 years. In this case, the statute at issue is Section 14. Section 14 provides that an attorney that mails or publishes the notice of sale can only do so if it's been provided written authorization.
Is that the only conduct that requires written authorization under that statute?
No, Your Honor. In that statute, there are 4 entities that can publish or mail the notice of sale. And each entity must be able to show a document that shows that they could do that. And the entities are first the mortgagee. The mortgagee is the first entity that could send the notice of sale. And the mortgagee has a written document. It can point to the mortgage to show that it has the ability. The second entity would be a person expressly authorized in the mortgage. Once again, can point to the mortgage to show written proof that it has the ability to send this notice. The third is a guardian or conservator. Once again, there'd be a court document, there'd be written proof. Now, the fourth is an attorney. And historically, there would be no need for an attorney to have written authorization, but the legislature spoke on this. And in 1906, included a requirement in the statute. And that requirement says that if any attorney is going to send this notice, it must have written authorization. It's the plain language of the statute, and that's what's controlling in this instance. Now,
So when it says person acting in the name of such mortgagee or person, which one do you put that?
That only relates to the last term. So the statute reflects a series of ors, and there's commas on each one. And as you could see, it applies to a guardian, conservator, or person acting under the mortgagee. And if the statute was not read that way, it would render the other terms superfluous, because there would be no requirement to have a clause for an attorney, because it would just be under this catch-all, a person authorized by the mortgagee. Now, my opponent argues that the Cranston case from 1867 controls here. But that's plainly wrong. The Cranston case was about an entity that someone that would only on oral authorization act. And that was before the 1906 amendment.
The husband acting with for the authorization of his wife?
Correct, Your Honor.
And your position about attorney as in representative capacity, because it was very clear from the foreclosure notice that who the mortgagee was, wasn't it?
I would not say it was very clear, Your Honor, because
Clear? Was it named?
The mortgagee was named, but it was on the firm's letterhead. And for a homeowner getting this, it says Orleans Moran, that's the law firm that sent the notices in this case. So, I mean, whether it was clear or very clear, it was on the law firm's letterhead. And the law firm admits, if we go to Record Appendix 65, which is the affidavit of sale, or Record Appendix 40 to 43, which is the Mulligan affidavit prepared, the law firm admits that it sent the notices. So it doesn't matter if it was clear who the mortgagee was. What matters is who sent the notices. The
Because of the way
statute
the statute reads, you're saying the person, those are the only ones who can perform all acts authorized or required by the power of sale.
Yes, Your Honor. And is this,
So Callahan, when it says it doesn't mean an attorney acting in a representative capacity is different?
the Callahan case is incorrect. The Callahan case in the appellate division says that this only applies to attorneys acting in their name. But that would render the statute meaningless because no attorney forecloses a property in its own name. An attorney does
did this
it on
court
behalf
say?
of its mortgagee.
What did this court say?
This court at the SJC only addressed the issue of whether or not the notices had to be under seal. In the Callahan case, Fairhaven Savings Bank supports.
So the only thing when it's referring to it borders on whatever it said, that somewhat.
Yes, Your Honor. When it says it borders on frivolous, it's only talking about the seal. In the Callahan case actually supports my position because the Callahan case, it was, if you look at the affidavit of sale in there, it was the mortgagee. It was a different prong of Section 14 that signed the affidavit that sent the notices. In this case, the attorney sent the notices. In Callahan, the mortgagee sent the notices, a bank executive.
Are there some things, though, that we've said that there are foreclosure-related conduct, that it's okay for attorneys to do without written authorization?
No, Your Honor.
There's nothing.
Well, Your Honor, let me be, I'm sorry. If there's a statute that says an attorney needs written authorization, then the attorney needs written authorization. If there's not a statute, if a bank had an attorney represented in an eviction case, there's no statute that says you need a written authorization to go to court on November 3rd. But in this case, there's a statute that says you have to have written authorization before you send these notices. They didn't have it. They didn't follow the law. Now,
A mortgagee can act through an agent, correct?
yes, Your Honor. But in this case, where there's a statute that says the agent has to have written authorization, then
You say that, but I mean, it says the mortgagee. If the mortgagee were indeed Fannie Mae, not some employee or agent of Fannie Mae do it on behalf of Fannie Mae?
yes, Your Honor. But in this case, it was not an agent. So for instance, if there was a,
The lawyer identifies himself as attorney in fact for Fannie Mae, doesn't he?
in the notice, yes, but still, because of the statute, there'd have to be a written authorization. If, to turn to your question, Chief Justice, if the general counsel were to do this, and he would act as an agent of Fannie Mae, then when he signed the affidavit of sale, he would say, I, general counsel of Fannie Mae, not an attorney otherwise authorized. To read it otherwise would just remove that part of the statute from relevance, because when would it apply if it always was that the attorney was an agent of the mortgagee? There would be no purpose to have that, and we can't read a statute to render part of it meaningless. There's 4 prongs. If we always count an attorney as under the mortgagee prong, then it renders the attorney prong meaningless. And that's not how we interpret statutes.
Well, you say that, but I mean, the other provisions, the legal guardian of such mortgagee, if there were a legal guardian, would it be I, as legal guardian of John Doe, do this? Would it be John Doe through his legal guardian do this? I mean, I'm looking at the context of the other alternatives.
Chief Justice, are you referring to the language that would be used in the affidavit of sale or in the notice of sale?
I'm referring to the language of Section 14, which says, or the legal guardian or conservator of such mortgagee. Just wondering whether or not it suggests, it gives a variety of people who could be acting on behalf of another. And going to the point that you say that if it were to be defined to be an attorney acting in his or her name, the provision would be meaningless. And I'm trying to see whether whether the context matters here.
When I say it would be meaningless, I'm referring to the fact that Orleans Moran, despite the fact that it's done many foreclosure in Massachusetts, to my knowledge, has never done a foreclosure in its own name. It would always do it in GMAC's name and say, as attorney for GMAC, which would put it comfortably within the attorney that needs to be authorized in writing under Section 14. And the Section 14 notice was specifically addressed by this court in Ibanez as being at the heart of the power of sale. In Ibanez, the case involved mortgage assignments, and this court held...
But at the time of the notice, the purported mortgagee didn't hold the mortgage, right?
Yes, Your Honor, but the decision in Ibanez also says that they had to hold the mortgagee had to hold the mortgage when the notices were sent. And the court says that Section 14 is one of the statutes that must be strictly adhered to. So in this case, there was no strict adherence to Section 14.
Is there any legislative history?
I do not have
as
any
to-
legislative history from the 1906 amendment, but I think that based off the fact that the other three people that can send the notice all have written proof, it
So
can
you
be...
said the other three, meaning the mortgagee or person having a stake in the land mortgaged, or a person authorized by the power of sale, so that's it, or the attorney duly authorized by writing under seal, or the legal guardian or conservator or of such mortgagee. And so you're reading this, or person acting in the name of such mortgagee or person, as being not a separate category?
No, Your Honor, I'm reading that as within the same category as the guardian or conservator. And because of the location of the commas in the statute, in the way that it's set up, that is one last fourth clause. And as I had mentioned, if we were to read that as its own clause, it would undermine several of the other ones, making them superfluous.
So you're saying somehow that in 1906, the legislature just decided for no stated reason to do this? I mean, it's certainly a number of years after the 18-something or other decision with regard to the husband and wife.
Nevertheless, it did overrule that decision, even if the statutes passed.
Overrule that decision?
Yes, Your Honor.
How did it overrule the decision when no attorney was involved in that one?
Your Honor, because in that case, we had a situation where someone posted the notice of sale with oral authorization. It's clear after the 1906 amendment, there can't be oral authorization. There needs to be a writing.
If it's the agent of a mortgagee, where's the writing?
If he's an agent of the mortgagee, what would happen is the notice of sale would say Fannie Mae is, GMAC is foreclosing. And then in the affidavit of sale, it would say as agent of GMAC, if they chose to use an affidavit of sale to prove their
What
case.
does this say, as
And-
attorney in fact for,
No, it wouldn't. If it was an agent,
no,
it would
this
just
one,
say,
what did this affidavit of sale say?
this affidavit of sale said as attorney, it may have said as attorney in fact, but nevertheless, Orleans Moran is not simply an agent. It doesn't fall under the first prong. It falls under the attorney authorized under writing. Now, if this court were to carve out an exception to Section 14, it would undermine the 100 years of jurisprudence which say that the power of sale must be strictly adhered to. It's the trade-off that's made, and it would undermine the system we have in Massachusetts that banks have to police themselves since there's no court to provide any oversight. A homeowner needs to be assured that they have that protection.
Now, so let's assume that you're correct about how to read the Section 14. But there were subsequent written authorizations provided. You don't mention the one that was done on November 28th, 2011. You do mention the one that was done on April 26, 2012. But why wouldn't we say that this sort of took care of the problem?
Your Honor, because the fact that the attorney was not authorized in writing means the notices were void, and a void act can't be ratified. In this case, GMAC knew that it had to send the notices. It knew it was required, but it didn't do it. It waited till after the notices had been sent, and then when it did it, it authorized the wrong acts. The authorizations don't say you can send a notice of sale. What they say is you can make bid at the foreclosure sale. You can make entry onto the property. Their attempt at authorization, they knew they had to do it, they failed, they waited too long, and they authorized the wrong
Wasn't it in connection with
act.
Section 15 that those authorizations might have been done?
That's possible. Section 15 has its own independent authorization for someone to sign affidavits. So you're correct. It could be authorization for an entirely different act.
But you're saying that even if we were to allow retroactive ratification, it wouldn't work here because the authorizations were not adequate to the task?
The authorizations, my position is that the attorney has never been authorized because the authorizations were inadequate, and regardless, there can't be ratification because the act was void, and a principal cannot authorize a void act. Turning quickly to my second point, in this case, the bank failed to establish its prima facie case. It can either do it with the short form affidavit or the long form. Each has its own indicia of reliability. One, personal knowledge, and the other one, detail. The affidavit in this case fails on both, and the bank has failed to provide competent extrinsic evidence, as their only other affidavit was not based on personal knowledge either. I see my time is up.
Okay, thank you.
Thank you.
Mr. Bryansky, good morning.
Good morning. May it please the court, Richard Bryansky on behalf of Federal National Mortgage Association. Your Honors, the plain language of 244 Section 14 simply does not support the position articulated by the Regos.
What does attorney duly authorized by writing mean to you?
It means that if the attorney is actually going to exercise the power of sale, then they need to be duly
How
authorized.
could they do that? How could that happen? How could the attorney do that? Unless the attorney owns the property himself or herself.
Or they're actually going to conduct the foreclosure sale in their own name. I mean, why
How
else?
could you do that? I mean, in their own, what does that mean? I'm having trouble understanding what that, give me an example of when that would happen.
I could, the only example I could understand is when the attorney actually is going to take and foreclose in the attorney's own name. For example, if Orleans Moran foreclosed in its own name in this
But why,
particular
why
circuit.
would he? Why would he have authority to do that?
As far as I know, it's never been done. But why else would it be under seal? Everyone's omitted the word under seal, and under seal was,
Isn't there a statute that says under seal doesn't matter?
well, yeah, but at the time the statute was enacted, under seal was significant to transfer a property interest, right? That was the only way a property interest could be transferred. Why else would that be included? What was the legislature's intent of including under seal in
why don't you
1906
answer-
when a seal was
Why
required?
don't you answer the question that I'm really curious about, which is, give me an example of some instance where this would actually be meaningful, where an attorney duly authorized by writing, under seal, fine, it doesn't matter, but when would an attorney be foreclosing on property in which someone else is the mortgagee, but in the attorney's own name? I don't understand how that could happen.
I've never seen a circumstance where
I
it
know
happened.
that. So, I mean,
So
can you
I-
come up with any example that gives meaning to this term?
No, Your Honor. I mean,
No.
it's simply, it would be, that's the only logical explanation given the
Or the
specific
logical
provision.
explanation is that the attorney who's going to be doing, even in a representative capacity, which is the way attorneys work, is required to be authorized by a writing under seal.
But if that were the case, Your Honor, why would 244 Section 15 require an additional writing? And that writing under 244...
Because that's a different requirement.
But wouldn't it be one and the same? I mean, what's the purpose of the writing under seal? An attorney can act as an agent for the mortgagee and foreclose. What's the additional statutory purpose for requiring
But we don't
written
usually,
authorization under seal?
we don't usually, when we construe statutes, see something as having absolutely no meaning.
Well, you I take it, you would say that it means if the attorney was actually acting as the agent for, and right?
In
I mean-
conducting,
Opposed to the lawyer.
As opposed to the lawyer.
that's correct.
So the agency relationship in that example would have to be in writing.
That's correct. But one of the issues here is the legislator specifically required it to be under seal. And when you try to analyze the specific language of the statute, what would the purpose of being under seal is? And that would to describe the transfer of a property interest, at least in 1906, when that specific statute was created. And that's consistent with the interpretation that we've articulated for the court, that this is a transfer of a property interest, i.e. the mortgage, to go ahead and foreclose. And when this court interpreted this specific language in Ibanez, it's consistent with the position we're taking, meaning that the purpose of the statute is to provide notice to the mortgagor. How can you read this particular provision requiring, presumably as the Regos have articulated, additional authorization if you're not exercising the power of sale. Here, what's pretty clear from the record is that GMAC was exercising the power of sale. The intent of the statute is to allow the mortgagor notice as to who's exercising that power of sale, to have an opportunity to protect their equity of redemption. I mean, that's what this court found in Ibanez. That's why it was such a critical issue, and that's why it's such a critical statute. That's what it was designed to do. And the statute identifies who can exercise the power of sale in that first provision, and then provides, more importantly, as this court found in Ibanez, a notice provision. Not only one notice, but a series of notices. And those notices are specifically designed, and that's really the heart of the statute, right? It's designed to provide notice so the mortgagor can take whatever efforts necessary to protect that equity of redemption, because that's important before the gavel goes down at the auction to protect their rights.
So if the person who was actually doing the foreclosing was the treasurer of a corporation, there would have to be a corporate vote authorizing the treasurer to do that. I know there's some statutes that say the president and the treasurer, if they both sign something, that you don't need a vote. But if a treasurer of Fannie Mae, for instance, was actually conducting the foreclosure on behalf of Fannie Mae, you would need a corporate vote authorizing that person.
I mean, that to me is more corporate formality, and I think that's a distinction that I would draw here, and that's a distinction between void and voidable, but I don't think we're on that issue yet.
But the other people who can bring the foreclosure are people who are acting essentially under authority that was vested in them by a court, like a legal guardian or conservator. Or the other alternative is the person who is the mortgagee himself. And as I'm looking at this, I'm seeing that there's a level of formality or an aura of formality that is required even for the attorney to proceed with the foreclosure, and that is by a writing under seal. There seems to be, in each one of these instances, if you're not the actual mortgagee, there is some aura of formality.
Well, how would a mortgagee that's a corporation act other than through its agents?
By a corporate vote.
I mean, but there's nowhere in there that says a corporate vote, and clearly contemplated in there is the mortgagee is could be an entity other than a specific person.
So, yeah, your point is that the statute is about notice of who's exercising. And here, you would argue, I take it, that it's very clear that who's exercising is GMAC? Is that?
That's
Right,
correct.
And not the lawyer in
And
his
not the
own
lawyer,
name, or
yeah.
is it?
And I think that's fairly clear from the record. Each and every notice was fairly clear in identifying GMAC as the mortgagee foreclosing, all the way through all the statutory required notices, even the assignment of bid and the foreclosure deed are all consistent. Likewise, so too Orleans and Moran identified themselves not as agents conducting the foreclosure, but rather as agents acting on behalf of GMAC, and that's all the way through. So there's no ambiguity. To me, the articulation of this additional requirement only creates additional ambiguity. And there's not even a requirement that this particular writing under seal be recorded or identified to the mortgagor. It doesn't seem to have any purpose other than...
The legislature just passed this amendment in 1906. Had a reason. Do we know when the idea of a power of attorney commenced in Massachusetts?
I don't know, Your Honor.
I'm sorry, Justice Link?
Oh, I was going to turn briefly to Section 15, because I was wondering, number one, whether you felt that this too was something with which there had to be strict compliance. As I read it, it also says, the person selling or the attorney duly authorized by a writing or the legal guardian or conservator of such person shall, after the sale, cause a copy of the notice in his affidavit and so on and so forth, to be recorded in the registry of deeds. Now, your client had two written authorizations, as I suggested before, one in November 28th, 2011, and one April 26, 2012, presumably to meet that requirement. If there were no written authorizations, would there have been compliance with Section 15?
If there were no written authorizations?
Right.
I would say no, Your Honor, because 254, Section 15 expressly requires a written
An attorney duly authorized by a writing.
by a writing. That's correct.
And so you think that that's required in Section 15, but that Section 14 requirement of an attorney duly authorized by writing under seal is somehow not applicable.
Well, and I would draw a distinction between the purposes of the two statutes. The purpose of 254, Section 15 is evidentiary in nature, i.e. you're creating an affidavit to justify, to contemporaneously identify the specific statutory steps that were taken to enforce the power of sale. That statutory affidavit ultimately becomes prima facie evidence in a summary process proceeding to demonstrate compliance and shifts the burden to the mortgagor or the tenant in possession. I think that specific statute also further supports our argument that that this writing, that what they're talking about in 254 Section 14 is different than 254.
244.
244 Section 15 is materially different, meaning that it shows that the attorney is actually going to be acting on behalf of the mortgagee. The legislature anticipated that in a representative capacity. And that's why, if you read it further, it also says it allows the attorney to identify actions of either the attorney or its principal. And it says, or the acts of the principal. That's what the affidavit
Yeah, the
says.
principal or the ward, because it could have been by a guardian or conservator.
Yeah, and that's really what 254 Section 15 is. And to address, you originally asked whether I thought strict compliance with 244 Section 15 was required as part of the statutory power of sale, and I would say it's not, Your Honor. I think there's dicta in some cases to indicate it's not, because it's not really, it's evidentiary in nature, meaning it's not really part of the notice process.
But this is not part of the power of sale?
I would say it's not part of the power of sale. All it is evidence of compliance with the power of sale. There's nothing in there, and it has an evidentiary purpose. Other than the evidentiary purpose, it's post-foreclosure, it's after the foreclosure had happened. So it would have no notice purpose and no purpose to protect the equity of redemption of the mortgagor.
If I can turn you to the jurisdictional issue. Tenant has two counterclaims. One goes to possession, one does not. If the case is tried, what happens with regard to it? The case is tried.
In the abstract.
If the case were to go
Hypothetically.
go to trial, or would be ascertained, and a judgment would be issued on behalf of the landlord with regard to the issue of possession, but granted with regard to the tenant as to the other counterclaim, in your view, that would have to be dismissed because there was no jurisdiction?
That's correct, Your Honor. I'm not 100% sure I'm following you, but
Well, I'm trying to, you basically have this notion that once you resolve one counterclaim, then the other counterclaim has to then be dismissed and be brought in another court.
I'm not sure we have, just to correct you, I'm not sure we have that notion. The notion was here that judgment actually entered, and I know the facts you're giving me are different than what we have here, but here actually judgment entered for the landlord for possession, or in this case, the foreclosing mortgagee. The 93A claim, which was dismissed, was completely predicated on wrongful foreclosure. It was impossible to reconcile the two. So there was no independent basis for them to attend.
So you're saying it was dismissed not because of lack of jurisdiction, but dismissed because you could not, regardless of jurisdiction, you could not prevail on the counterclaim in light of the judgment with regard to the possession.
Well, we argued both grounds, Your Honor. I believe we argued both.
And the judge's notation didn't identify which one he was going on?
I believe it was just a side
Right.
notation on the pleading
Just
itself.
allowed, or? do you-
I don't remember the specific notation, but it wasn't overly detailed. And it's in the record, I forget which. And the two hearings, there's not, both of the transcripts are in the record, but there's not a lot of.
But in Chief Justice Gantz's hypothetical, if you've got two counterclaims and say judgment hasn't entered yet, so the issue of jurisdiction in the housing court on the 93A claim that doesn't relate to possession
What do you say to that?
We would take the position that there's no basis for jurisdiction, and that would, in our opinion, interfere with the summary process.
Well, but you don't think Rosa goes to that at all?
Well, doesn't Rosa say grounded in possession? I mean, those are the specific words this court said. If it's
Well-
grounded in, and I shouldn't say specific. I'm not reading from the decision. That's based on my memory.
Well, so I take it that this dilemma could be solved at least by an administrative order where the Chief Justice of the trial courts could authorize the housing court judge to sit as a superior court judge for purposes of hearing this other counterclaim.
That's true, Your Honor, but I guess my problem would be, and it's more of a practical one, it's consistent with the underlying policy of summary process.
That same argument was made in Rosa.
That's true, but I think this is a little different here, where you're talking about a 93A claim which is not grounded in possession and has really no bearing whatsoever on the underlying claims which are being resolved by this summary process action. If it's based, and think about how it would happen practically in the housing context, especially with these foreclosing mortgagees. You're not attacking the actions of Fannie Mae, but rather, or the purchaser at foreclosure, you're attacking the servicer's actions, which is what the 93A claim in this particular case was predicated on. The summary process case wouldn't have any jurisdiction over the servicer. Now you're talking about bringing in a third party who otherwise wouldn't be available. You're talking about expanding discovery, and you're talking about impacting the rights of the foreclosing mortgagee to that just and speedy trial that summary process was designed to provide.
So if they didn't bring the counterclaim, would you, this particular counterclaim, but brought it after the underlying landlord-tenant case had been resolved, would they be susceptible to a motion for failure to bring a necessary counterclaim as a mandatory counterclaim?
Not in summary process. The uniform rules of summary process don't have compulsory counterclaims specifically for that reason. I think it's Rule 5 that articulates that these types of any counterclaim is permissive in nature, so there wouldn't be any res judicata effect or any negative impact on the mortgagor or whoever the possessor of the property is.
Okay, thank you.
Thank you.